Hey, everybody. I know you weren't expecting to see us today, but tomorrow's technically the day before Thanksgiving and we won't be here. And I think I even said we might not be here, but people have said, where are they? They disappeared. And I'm going to tell you, it's because Greg decided to go to Paris. Threw us all off. Greg's fault.
I'll take the blame.
I'll take the blame. And I, even though I was with him, it was really his fault.
I like
that we weren't here. That's Greg's fault. Hey, we want to talk first about the actually, guys, before I get into, because I know this question's going to come up, let's just talk about Go and the DV 2021 and the Gomez Ackridge. Today, we have no news. Although the oral argument yesterday on the Trump gag order was fascinating. The DC Circuit will almost assuredly issue that decision before we get this decision. So we have no news. Don't know what's going on. Boom. All right. So there, I just wanted to throw that out there for folks because we didn't forget about them. All right. The 601 delay litigation with Ayla. Where are we at this? What's going on?
Well, I just posted the kind of pacer information from the argument in Mercado. So it was Judge Hawkins, Collins, and Murphy. So
now Judge Hawkins, I used to work with him.
No kidding.
Judge Hawkins, when I was a brand new associate in 1991, he had the office next to me, and he had fish. He's one of those guys that had a fish tank in his office. Weird dude, but he was very, very heavily very all Democratic politics in Arizona. I was working in Arizona.
Yeah.
And I was assigned to work. He wasn't an immigration lawyer, but they needed me to work on something because they needed a body on a case. And I worked on it with him. And I did exactly what he told me to do. Exactly. It wasn't complicated. And then he yelled at me for doing exactly what he told him to do. So I told him to F off. I would never work with him again. And so that's my dealings with Judge Hawkins. But he is a stubborn old coot. And he's got to be about 80 years old.
Well, I mean, that's actually good intel because it's essentially what he told the plaintiffs in the 601A case. On the reverse side, I mean, it was a bad argument. It was.
Yeah, can you explain kind of like what these other cases that are not our case, what they have to do with us?
Yeah. So, well, first, the Circuit Court of Appeals is one step below the Supreme Court. So usually, unless they're overturned, when they make a ruling and they publish the decision, that ruling on an issue is going to take care of any case that's within that circuit. And so our 601A case is in the Ninth Circuit, and that Mercado decision is going to dictate the outcome of our case because the threshold issue was about, can the court even look at a delay for a 601A waiver? It doesn't matter if it's out of order or not. Can we even take a look at whether the delay is happening or there, anything having to do that? And the answer, from what I can tell, is going to be no. The court has no business being involved in 601A waivers. And that will rule the day for us, to be quite frank. I mean, you just have to be ready to embrace that. And that is, it's terrible. And honestly, it's not, there's no real fault to go around. I don't think Atticus Finch could have been there in the Ninth Circuit and that would have changed it. It was just the court reads the statute in a way to say that the federal court system has no business getting involved in delays of waivers and especially denials. And so that's where we're at. And now if the Fourth Circuit were to come out the other way, maybe the Supreme Court would get involved, but
I'm going to ask for speculation. I mean, I think this is going to the Supreme Court. I don't know when. I don't know if it's this year, next year, the year after that, but I think this issue is going to the Supreme Court. How do you think the Supreme Court as made up will assess this?
I give you my impression on that. I don't think they understood Patel and the consequences of what they wrote in Patel to mean that it would do this. I don't think they continue doing what the circuit courts are thinking they thought they meant when they issued Patel. That's my opinion.
Yeah, I would not take, if I wanted to get more clarification on Patel, this would not be my case, because it's the statute, is not drafted well. I would take another delay case and have them make a decision on what the APA covers and what it doesn't. And because that's really what we're seeing, is that they're really reading out the part of the APA that requires federal agencies to act within a reasonable time.
They're just ignoring it.
And they're just saying, hey, you know what, the hell with it. And I will say this, and this is actually a fact for once. I have seen more motions to dismiss denied across the country in the last 2 months than I saw in the last 3 years.
That's true.
Full stop. It's happening because the government is getting stubborn and also overconfident in how they're going about telling people that they can do whatever they want whenever they want and shut up. And so the only court that's not is DC, and they are, I don't know. I mean, honestly, it's like conspiracy theory time, because they're so behind the ball, to be honest. So, the other thing is this. There's an election coming up. And so I think actually, people look at this and say, we need to, maybe pull back a little bit. And I think it's full speed ahead, because I got to be honest with you. I mean, if you think that the cavalry's coming in 24, we're going to get more of the same at best. And that's not good enough. And the worst case scenario is really bad. So I actually think the Supreme Court and Justice Gorsuch and his buddies up there and would take a very big step in coming back to reality with what the APA allows federal courts to do, because that's really what we're talking about.
Exactly.
Us. Yeah. It's not about us. They don't care about us. They care about
with their power. There's no way Gorsuch is going to, let's say, oh, we don't have power over this. There's no way.
And here's the thing. There are specific instances where, the INA will tell the federal courts what they can and cannot do. But the presumption is that there is review, and there is nothing in the waiver provisions that say, or that would anticipate, that a court could not have its regular review when the agency does nothing or basically shuts down the program, which is what it did.
Well, it's something Trump actually did do. They actually, and they did do it here. Yeah. They actually shut down the 601A program. They clearly did.
Yeah. And here, last thing to tie it into the Gomez and Goodluck and Go case, that is the DC Circuit's opportunity to, when they do write their exegesis on this decision, for them to actually tell the federal agencies that courts have a role. And if you actually play fast and loose with the rules, we can order a remedy to, help those that you harmed. And that's essentially what we're doing for all delay cases. Right. It was, it's really ridiculous that courts, and I think this is what happened in the DC circuit. This is what happens in DC, and this is what happened in the Ninth Circuit. They look there and they say, geez, we're overwhelmed. We really like to go golfing most of the week. So what's the best way for me to not do my job but still wear a robe and pretend I'm important? And that is because I'm for life. I'm going to go with Clarence Thomas on an RV trip around the country. I don't want to do hard things. So I'm just going to tell you I can't have jurisdiction. I think that's bullshit. I think all these federal judges need to buck up and do their job. And that's the reality.
The thing is, they wouldn't have to do their job if the government did their job. And yes. If I can point to one thing about this case in particular that I believe we won on, is that we forced USCIS to publicly say that they, within 12 months, starting 2 months ago, that they would adjudicate these cases in 12 months. Now, if 12 months from now, they're taking 3 years on these cases,
Yeah.
I think we have an incredibly different case than we have today. But I view that as a victory to force them to come to the table to adjudicate. Now, it doesn't do it, I know, but it doesn't help. How does it help me? I mean, because every one of our plaintiffs should be adjudicated in 12 months, which gets me to my question to you, Greg. How many do we have been approved so far? Have you? Can you look at?
I have to. Let me find it.
Use your magic crayon and figure out what that number is.
I will tell you un momento. We have 71 approvals.
Okay, which means we still have 220.
225 pending.
And does yours say how many might have RFEs? Probably not many.
I don't know that.
I mean, maybe you. I don't know if you guys monitor like I do the lists, the Facebook group for our plaintiffs, but one of our plaintiffs got a hold of an officer and just talked to them about these cases, and the officer basically said, "We're trying to approve as many as we possibly can." You know, the standards is just. Is life going to be hard for you if for your spouse if you can't come back? That's what they articulated the standard as, and evidenced by the fact they're basically approving almost every case of our plaintiffs with minimal RFEs.
Yeah, I mean, we are seeing steady approvals coming in. The last one was on November 17th.
Can you tell when the date of filing was on that case?
May 2020.
Well, if they're up to May 2020, that's better than November of 2019. So at least they're pushing forward. And now this officer also told the person that they're almost fully staffed on Hart and that they're really trying to get these cases done, pushed through Hart. So take that for what it's worth, but that comes directly, the court, they would call that double hearsay and be completely inadmissible, but it's still interesting.
Well, I mean, I'll give, that case in Colorado, though. I mean, it just goes to show you that the federal courts could actually spur changes, because as soon as they ordered discovery, they adjudicated all of them. And the same thing happened in
an EB-5 case, right?
Yeah. So, I mean, I think federal courts, rather than say, take the ostrich approach to jurisdiction, they could just simply say, hey, wait a minute, we're going to
I need to see what's going on here.
Yeah, I just want to see what's going on. Let me just see how you're doing work. And, maybe there's something there and maybe there's something not. But every time we look and get the something there, they settle. So, and that goes back to the H4, L2, the EB-5. So maybe there is something there. And why not do it? Literally just let us go forward to summary judgment, maybe with a little discovery and see what's there. What is
an EB-5 case? All right, we're going to jump over to the Boule case.
I just want to mention one other thing related to the data on there. One interesting thing, make of it what you want, is that we have we have the 71 approvals, no denials. So
none.
No, which is there's always this question of do I hurt my odds by litigating on there? And I think just the general odds out of that group of 71, all
somebody would be denied. I mean, statistically,
the normal odds are that somebody would get denied for something on there. So you make of that what you will, but that is, I did see that as kind of interesting.
Speaking of approvals, Mr. Hall, tell us about Boule.
Well, it was kind of a good lead in there because we're talking about the prospects for appeal, and we got our denial in the Boule case, we got our dismissal from the judge in the Boule case. And we're in the period where we have to decide whether we're going to file a notice of appeal, and that would go to the 8th Circuit. There are a number, Jesse was just saying that there are a number of kind of similar cases already pending at the 8th Circuit. And so it's unclear, at least to me, I don't know exactly where those are. It's unclear what the chances that we would be consolidated with those cases would be. But we've been going back and forth between us about what the appeal would look like. We have 8 people who were approved of the original 20 plaintiffs. We have 12 remaining. 1 has already been RFE'd, so I'm not sure to what extent they are interested in being part of the appeal. And we've been talking about, what would the appeal look like? What are we going to do? And I think we've just come to a conclusion that we're going to file this appeal and just waive legal fees on it. We just think that this is really important. We're passionate about this, as you can probably tell by hearing us every week, and we want to battle for our clients to get these waivers done. So the people who are plaintiffs in Boule will be getting an email today about that. We will need them to respond. We will need them to sign an agreement because we still need authorization to officially represent you on appeal. And then we will, once we have that, we'll get the notice filed and get the appeal working. I feel, maybe I'm naive, but I don't know which cases are going to win on appeal. Might not be ours, might be ours, but I feel strongly that ultimately we're going to prevail on this issue. The statute just doesn't say what they're saying it says. And I like Jesse was kind of alluding to, I don't think that that the people on the Supreme Court, including Justice Gorsuch, who are very skeptical of administrative power, are going to cede all of this to the bureaucracies and just say, hey, courts can't touch it. So
Justice anti-Chevron, I do not see him saying, yeah, government agents can do whatever they want. There's no oversight whatsoever from the courts. That's insane. It's an insane position to take.
Yeah. So anyway, if those plaintiffs, please keep your eye on your email boxes. I know we're going into the holiday, but prompt responses would be appreciated. Thank you.
All right. So that was my new phone ringing because apparently I didn't change that I was no longer available. So the new e-phones. And we hopefully will be hearing about our EB-5 plaintiffs because they're supposed to be all adjudicated by the end of the year. So, I mean, they still haven't done them all. So I'll follow up with government counsel and say, what's going on? I thought they were going to be adjudicated all before the end of the year. They do not want to have me reopen that EB-5 case because the judge will not be happy. All right, let's look at a couple questions here. Jagoda asks an interesting question. What happens if I depart the United States while my 601A waiver is still pending? Well, you activate the 10-year bar and you're waiting abroad to come back. That's what happens.
Hey, Chuck, by the way, we didn't mention anything about the Axtova case.
Yes. I'm sorry, Greg. I'm thinking the case for recovery of fees for the U for You program.
Right.
Greg, you want to give us a brief update about that?
Well, I mean, we don't really have that much to update
about that, right? So
it's been, the government right now is fighting over procedural questions, not on the substance of whether they actually owe money or not. Presumably that'll come later. But the case is now in New York, and we kind of, we're having to basically start there again. They're likely going to try and push that judge to put this case in the Court of Claims. If we have to go to the Court of Claims, we will go to the Court of Claims on it. But there were some strategic reasons why we didn't want to go to the Court of Claims. I don't need to get into that here. But we feel pretty confident that this case is ultimately going to result in refunds being issued. The only question is how long the government is going to try and throw up roadblocks before that actually happens. As far as
we learned, Greg, inflation will make the $410 irrelevant.
Inflation's down.
I know inflation's much better. What's interesting about this, the new judge was assigned the case, and we were assigned, by the way, to the chief judge of the Eastern District of New York, a former like Catholic Charities lawyer, a former public service lawyer out there. She had set a hearing, and then the party kind of responded and said, "Well, Judge, we don't really need a hearing on this case. So as of right now, we're just kind of waiting for the government." I'm looking at Pacer right now. Kind of waiting for the government to act on this case.
Well, what's happening is that
December 12th is the hearing. We have hearing on December 12th, right? So
yeah, what we said was, or what the government said was, that the case is subject to a statutory stay, so nothing can happen until December 5th. And after December 5th, we requested a conference as soon as possible.
So we have one on December 12th at 10 a.m. and we will. That is a Tuesday, so we'll be able to update it in our live later that day how that call went. So there we go. Thank you, Greg, for that update. Let's go to some more comments here. We've got Bruno. Bruno's back. The Ninth Circuit actually rule on the Mercado case? No. Jesse is projecting after listening to oral arguments in that case. Where he thinks that case. So it's Hawkins. Who are the other two judges? I was so focused on Hawkins. I always hated that guy.
Collins and Murphy.
Collins and Murphy. Any idea who appointed them? Because Hawkins was appointed by Clinton back in the day.
I don't know, but I can tell you that whoever did not like them reviewing waiver cases.
Okay, Trump was appointed by Collins. And what was the other judge?
Hawkins and Collins and Murphy.
Murphy. So we've got looks like Murphy. Let's see here. Wrong Ninth Circuit guy. Apparently, there's a Murphy in the Judicial Circuit of Florida, Court of Appeals. Let's see who appointed this guy. Oh, come on, really?
He's actually Joseph Murphy III. So, actually, Stephen Joseph Murphy.
Stephen Joseph Murphy. No way he's Irish.
I'm just gonna let you know. Like I have things that set me off, and I just basically ignore people with certain. But having a name like that is definitely a red flag for me. Stephen Joseph Murphy III. Like he's probably on his license plate too with his initials. That to me is I just ignore you.
Yeah, I.
I'm very nice. Like, thank you. Yep. And then I'll see you at the dessert. I'm not talking to you. Yeah. Stephen Joseph Murphy III. Like, no, thank you. That's
obviously I'm having a hard time finding this guy on here. Let's see.
Check the Illuminati list.
Is he a circuit? Is he a circuit judge or a district court judge showing up?
He may be sitting by designation.
Because I can't find any Murphys that are Ninth Circuit judges. I think he must be sitting by designation, maybe from a different circuit.
I will say though, the audience, I mean, it's worth your time. It's only like 15 minutes. You can actually watch it and you can look at the demeanor of the judges and the questions. I didn't think that the counsel for the plaintiffs did a poor job. I actually thought they did really well.
He's a George Bush appointee, George W. Bush.
George W. Bush. Okay.
No.
So, yeah, it wasn't the best panel you could have picked in the Ninth Circuit.
No. Oh, no. Yeah. And that's what the Ninth Circuit has become. You know, it used to be you kind of knew what you were going to get, and now it's massive. Actually, you know, this is probably too much for today, but the Ninth Circuit should really be split, and they should make a 12th Circuit because it's just too big and too different, and it's arbitrary. Everything goes in bonk, you know, and
in bonk they have like 30 judges. They have some incredible number of judges.
It's time to do a 12th Circuit.
Yeah, it is, but they're not. You know, it would be better if they just split it and just deleted the 5th Circuit and just put them in. Just kidding. That would be even better.
Well, that was back in the day when they created the 11th.
Yeah, out of the 5th. The 5th is the 11th is a child of the 5th, and that's been about 40 years now. Julie Moreno, we can ask the president to use authority to grant parole. Yeah, but Biden's not going to do that. But you can ask, but he's not going to do it.
Well, he loves parole.
Yeah,
he added another one this week for Ecuador.
Yeah, even I'm asking Ecuador.
He should have just do like the Southern Hemisphere at this point, or like South America. Like let's
Well, this one is this is one of the ones with the I-130.
This is the family one, right?
Yeah, they come in two flavors.
They're
one
doing it in all the countries.
One and the other is the family reunification.
They're doing it in all the countries that surround the Darien Gap because they're using it as leverage to put our to do our enforcement work.
Well, Ecuador is not in the Darien Gap.
Yeah, but that's where they land because
Right.
visa free.
Yeah, or Peru.
You
They're
can
actually,
land anywhere.
most of them are actually
fly
going to
anywhere in the
Peru.
world to Ecuador without a visa, or at least you could.
Yeah. So, all right, Armando. Hold on, gentlemen. What do you think is going to happen with the Mercado case? I think you said it there, Armando. It doesn't look good with the panel we have. But you know what? Maybe we'll appeal to the Supreme Court. Although Jexy doesn't like this case on the Supreme Court.
I actually like it. You know, we have a fabulous attorney named Paul Hughes arguing in the Fourth.
Fantastic.
And I think that if the Fourth Circuit, which, you know, they're not afraid, they're courageous. They got some people on that court who will take a hard look and do hard work. And you know, if that comes out the other way, the Ninth Circuit's the most reverse circuit, still holds the record there. And so
the Tenth Circuit is trying.
What would be awesome is if the government did our dirty work and appealed that a favorable Fourth Circuit decision up, and that would be great. I mean, that would be
great.
awesome.
Well, there's no way they're not going to appeal it. Not with their current position. They're definitely going to appeal it. I just don't think that's strategically a good thing to do. But they could. Erica got her 601A approved. Congratulations. Now you just have to wait out Juarez for an appointment. Although Juarez is getting a little faster these days. I think they're anywhere from 12 to 18 months to set appointments, which is
speaking of faster, NVC is like good right now, right?
Yeah. What happened?
I don't know. We're submitting documents and hearing back within like 4 days.
Yeah, something's going on. Maybe they put somebody in charge that didn't want to get sued all the time. But the consulates are still kind of nightmarish. Erica, I finally got my. Oh, Erica, I did twice there. And do you guys think government could parole documented dreamers who are about to age out for their parents' EB-5? Yeah, I mean, parole is an extraordinarily broad power. But keep in mind what parole actually is in this context. I mean, parole is not really giving these kids status. I think it would be more likely for the president to authorize deferred action than parole. What do you think, Aaron? I don't think he would. First of all, parole is technically let you in the country. It's not designed for anything other than getting you in the country and then letting you get a work permit.
The only thing is that deferred action is kind of a creature of, it's in the regulations, but it's kind of a creature that was just kind of invented out of thin air, whereas parole has a statutory basis.
Yeah.
So
why couldn't the agency just come out with a policy manual saying that these situations qualify as extraordinary circumstances and they're going to freeze the ages of the kids?
Or the easiest answer is just let everybody with an I-140 file an adjustment of status application.
Change the dates for
Just, I mean, if they're already doing this, right? Dates filing, they're not current. So they're already acknowledged that they can accept adjustment of status applications for people whose dates aren't current. So why don't they just make it everybody?
I would love to peel back the onion on what the hell's going on with that visa bulletin. I mean,
I mean, Chuck, just to make the counter argument for the government, their position is that all those visas are available because as soon as the October 1st rolls around, all the visas become available for the whole year, and this is their projection of where they will be.
Except that's bullshit. I'm sorry.
I understand that. I'm just
true.
saying this is why the government's going to say they can't do it, because they're going to say that they have the numbers. The numbers actually are available for that fiscal year for that population. I mean, for that group, but that they're not going beyond
is there
that
a equal protection piece of litigation here available? I mean, is you're treating similarly situated people differently under the Immigration Act? Because again, they're not. Everybody in that with a judging adjustment clearly does, which is why they retrogress cases.
Well, there's a long history with the government of saying that it's impossible, and then suddenly it's possible because they accept a alternative viewpoint of a law, and that was a good example of where they got creative. And I guess this was 2014. They got creative and they were able to view it differently. They have been given the legal arguments for what you're talking about. In 2014, the ALA gave them some of those arguments, and Cyrus certainly has made a great case for that recently. So, if this administration is sort of like, it's weird. They will lean in sometimes and do really creative things that are benefiting lots of people, and then they sign a kind of a blind spot on other things where they will just dig their heels in. And this is a good example of something that would solve a lot of problems if they would take that position that you just suggested.
Yep, there you go. Hamza, we already talked about the Go affair. They're asking about the Eagle Act. I will simply say this. We're not talking about the Eagle Act in this forum. But you're welcome to tune into our individual Facebook Lives to get our position on it.
We have differing views.
But I will tell you this, because of the article that I wrote this summer on the visa apocalypse, that if the Eagle Act passed, which it's not going to, FYI, there's zero chance any positive immigration thing is going to pass. But if it did pass, the wait time for Indian nationals goes from 210 years to 40 years. Still a completely unreasonable period of time. And the rest of the world goes to 40 years from 10 years.
Although if the government takes the position, and I know that we got into kind of an argument with one of our able members when I raised this. If the government took the position that the language for derivatives which is identical to the H4 language, means that they shouldn't be counting derivatives in the numbers, that does free up about 60% per year extra green cards, which would dramatically bring down backlogs. So the Biden administration has the ability to do something pretty great if they wanted to in that space.
The calculation I did is it would go from 210 years to 105 years, maybe 90. And with the Eagle Act, it would go down to 25 years.
Right. But if they all of a sudden didn't have to count derivatives, I would guess probably it would still take a few years to clear everything out, but it would really probably improve things.
It would take about 40 years to clear Indians out, basically.
Well, all right.
I mean, the numbers are there. All right. We're not talking about it. Emily, why can't the parole persons approved on 40 get EADs person in a decade? Because they're not letting people file adjustments. That's why. Which they should do. Okay. Let's see. Parole in place. But again, parole's grace is great. But again, that's taking somebody who's undocumented to be documented. I mean, to parole, they now have a lawful entry, which then lets them adjust in an immediate relative context. But it wouldn't let somebody adjust in an employment-based context because it's not a status of any kind. They can wait for, you're Guatemala, Erica? Oh, that's great. That's probably 4 to 6 months. Is that about right, Aaron? My experience recently is 4 to 6 months for Guatemala. So those are our questions for today. It is great to see everybody. We're great to be back. We'll be back next week with hopefully some news about our filing of the appeal. And you guys have a fantastic Thanksgiving. I mean, it's still a wonderful place to live, which is why immigrants keep coming. And let's just all pray Donald Trump's not elected, because if that happens, these discussions become irrelevant because nobody's coming to let in. So
happy Thanksgiving, y'all.
I'm going to have a great one. I'm frying a turkey, by the way. It's going to be awesome. Hopefully not exploding a turkey, but frying a turkey. You guys have a great week. Bye-bye.
Bye-bye.